Hi, POL 105 class. We're going to continue on with our online lectures. Again, I hope everyone is staying safe and healthy out there. And what we want to do today is continue on with our lectures in regard to law. And what we've done is we've kind of broken them down into two major components. So the first component was what I tried to do is give you an overview of law and the legal system. And in particular, how is the national legal system organized to interpret and apply law in the United States? So we talked about United States District Courts, United States Court of Appeals, and we then said the United States Supreme Court. And in talking about the United States Supreme Court, we said that the United States Supreme Court is the most authoritative and important court in the United States in regard to national law. And as part of that, what we want to do today is understand the role of the United States Supreme Court in interpreting, applying, and adjudicating law in the United States. So, one of the things that we talk about when we talk about the Supreme Court is the role of the Supreme Court as policymaker. And again, we have to emphasize that the Supreme Court is the most authoritative court in this regard, but that the powers of the Supreme Court historically were somewhat vague. So if you look at our original Constitution, and the part of the Constitution which deals with judicial power, which is Article 3 of the Constitution, what you'll see is that Article 3 of the United States Constitution doesn't say anything about who should be the final arbiter of disputes that arise over the Constitution's meaning, or whether the United States Supreme Court had the power to review legislative and executive acts. So what was the exact power of the Supreme Court? And if you look at Article 3, I mean, really all it tells you here in this regard is in Article 3, Section 1, it says the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. So clearly what that's telling you is that the Supreme Court has judicial power and it is the most supreme of all of our courts. But what do? What kind of cases can they hear? Well, when we talked about jurisdiction, we talked about the kinds of cases that these national courts can hear. And in Section 2, it kind of repeats that. It says the judicial power shall extend to all cases in law and equity, so in other words, civil cases, arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. To all cases affecting ambassadors, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party. So if the United States is suing or being sued, these courts would hear it. To controversies between two or more states, between a state and citizens of another state, between citizens of different states, which if you remember we referred to as diversity jurisdiction, between citizens of the same state claiming lands under grants of the different states. So that's all it really said about the judicial power of the national government and therefore the judicial power of the United States Supreme Court. And as you can see, it doesn't say anything about, well, okay, who is the final arbiter of the meaning of the United States Constitution, which is one of the most important questions one can ask. And who prevails if the United States Supreme Court comes up with a different interpretation of the laws of the Constitution than the United States Congress or the President of the United States? Who prevails? Well, that's a critically important question. So we said that Article 3 did not answer that question. But eventually we do answer that question, and the question is, how do we answer that question? And the way we answer that question is through case law, and specifically the case of Marbury versus Madison, which is decided in 1803. And this was kind of a controversial case, and I'm not going to get into all the details, but just to give you a little bit of a background. Your book talks about it, so make sure you read it. What happened in this case is President John Adams was a Federalist, and he appointed William Marbury to the Justice of the Peace position just before Thomas Jefferson was to assume the powers of the presidency, and he was inaugurated as the new president. So we refer to these as kind of midnight appointments. In other words, an outgoing president appointing someone just before they leave office. So for example, looking at it in current politics, if President Trump were to lose this upcoming election, and then he says, well, I want to put Trump people in all of these judicial positions because they're positions for life, before Biden takes office because he's a communist and we can't have communists appointing people, then what I'm going to do is make all these appointments. So that's kind of what was happening. Adams was making these, what we refer to as midnight appointments, before Jefferson became president, was inaugurated. Well, what happens is Marbury's commission was inadvertently not delivered. So Jefferson then comes to office, and his new Secretary of State, which was the office in those days that made these appointments, was occupied by James Madison. And Marbury goes to Madison, look, I was appointed this judicial position, please appoint me. And Madison said, no way. And the Chief Justice of the Supreme Court was John Marshall. So Marshall had to decide, how do we resolve this issue? Well, the main thing, and again, there's a lot of politics going on in this regard, because Marshall himself was a midnight appointee of John Adams, and he obviously got his position, was how do we resolve the issue? And the issue was finally resolved by John Marshall by dismissing the case, saying that a congressional act that had given the Supreme Court original jurisdiction in these types of issues, the Judiciary Act of 1789, and I'll say that again, the Judiciary Act of 1789, was unconstitutional. So sorry, Marbury, you cannot get your commission, we're not going to award it to you. And that made Jefferson happy because he didn't want to give it to Marbury. But it made Marshall very happy because here he was a Federalist, here he was the Chief Justice of the United States Supreme Court, and basically what he was doing with this pronouncement was conferring this idea of judicial review on the Supreme Court, saying it's the United States Supreme Court that has the authority to say what's constitutional and what's not. And this power of judicial review has ever since been used by the courts in many ways to establish our national policies. And sometimes national policies which were strongly opposed by members of Congress and the President of the United States. So they give themselves this idea of judicial review, that they are the sole arbiter of the meaning and application of the United States Constitution, and their interpretation is superior to anybody else's, superior to Congress's interpretation, superior to the President's interpretation, which made the Supreme Court an incredibly important policymaker in the United States. And it has exercised its power for hundreds of years now. want to look at now is how the Supreme Court has used this power in regard to what we refer to as substantive constitutional rights. And when we talk about substantive constitutional rights, we generally break them down into two subcategories: civil liberties and civil rights. And again, your book defines these terms for you. But civil liberties are individual rights. They are freedoms from governmental interference. So when you think about civil liberties, you think about the Bill of Rights, the first 10 amendments to the Constitution. So you think about freedoms of press, freedoms of speech, freedom of religion, the right to be secure in one's home, the right to be free from police harassment and unreasonable searches and seizures. Those are civil liberties. Civil rights, different kind of issue. Civil rights deal with issues of discrimination and inequality under the law. So when we talk about discrimination, we're talking about to what extent can you legally deny people certain privileges based upon their gender, their race, their ethnicity, and or their religion. So civil rights cases deal with things like voting rights, access to education, marriage, housing, and the legal system and its organization. So, pursuant to this idea of judicial review, the United States Supreme Court becomes the final arbiter of what do we mean by our civil liberties, what do we mean by our civil rights. So when we say that you have the right to freedom of speech, what does that really mean? Does that really mean you can say whatever you want, whenever you want? Well, the Supreme Court has said no, it's not an absolute right. As freedom of religion is not an absolute right. You can't do whatever you want in the practice of your religion. If you say as part of your religion, I believe in human sacrifice, and then we're going to sacrifice the Vestal Virgin to the full moon once a month, and you say, look, state, you can't be involved because that's my religion. The Supreme Court said no. So very few of our civil liberties are considered absolute, which therefore gives the Supreme Court significant power pursuant to judicial review to determine how we enjoy these rights. And they do that till this day. We're going to talk first about this idea of civil rights. And what role has the Supreme Court played in the evolution of civil rights in the United States? Now, the book tells you that the legal history of civil rights in the United States is primarily the story of a search for political, social, and economic equality. And that this search has persisted for more than 2 centuries and is ongoing. So when we talk about civil rights, we talk about providing equality to our citizens. And what do we mean by equality? As you may remember, the second week of class, we talked about the concept of equality. And we said there are 2 types of equality. Equality of opportunity and equality of outcome. So we said equality of opportunity was defined that people should have an equal chance to develop their talents, and that effort and ability should be rewarded equitably. So it just offers the chance to get ahead. It glorifies personal achievement and free competition. So simply put, again using the example we did then, it's saying, hey, everybody can apply to Harvard Law School. We're not going to discriminate based upon your gender, your race, your ethnicity, your religion. Everybody can apply. That's equality of opportunity. But equality of outcome is a little different. Equality of outcome is trying to provide greater uniformity in regard to social, economic, and political power among all groups in the United States. So this approach promotes the idea that society must ensure that people are more equal, and government should provide policies that help redistribute wealth, education, and factors which have a major impact to what extent we can really succeed in our society. And I say, and if you don't do that, the inequalities of the past are likely to become perpetuated. So when we talk about equality of outcome, we talk about these ideas of benign discrimination and affirmative action, where many groups in our society say, hey, it's not enough to say you can apply. You've got to equalize some of these resources. You've got to make it sure that we have more of a chance to succeed, because maybe historically women were discriminated against. African Americans were discriminated against, weren't allowed to get education. That's why they're poorer. That's why the percentage of African Americans that are below the poverty line are higher than they are for any other group. So we want to look at civil rights, and we want to look at how the Supreme Court has approached this issue of civil rights. And in approaching civil rights and establishing the law in this area, what we can see is the court has gone through a number of different legal eras. And specifically, we talk about 4 legal eras. 4, well, let me print. I've been told by some of you cannot read my script. 4 legal eras. And the 4 legal eras are the following. First, legal discrimination. Second, qualified legal discrimination. Third, legal equality. And fourth, what we referred to before as benign discrimination, as epitomized by the idea of affirmative action. So what we're saying here is that when you look at this issue of discrimination, for most types of discrimination, they go through these 4 different kinds of eras. And what we're going to look at now is one particular type of discrimination, racial discrimination in the United States. Racial discrimination. And we want to look and see how racial discrimination evolves over time. So, when we look at the first era, it's an era of legal discrimination. What do we mean by that? when we talk about racial discrimination at the origins of our nation, and when we talk about racial discrimination in the United States, legal discrimination was the legal standard in our country from 1789 until the 1860s. So what do I mean by that? What I mean by that was from 1789 until the 1860s, it was perfectly legal to discriminate against people solely based upon their race. So if you were an African American, you were not entitled to the same kinds of services, benefits, and rights as white citizens were, especially white males. And how do we know that? Well, first of all, if you look at the original United States Constitution, there were no constitutional safeguards against depriving persons of rights because of their race, or for that matter, for their gender. What did the Constitution state in regard to race? The following kinds of things. Article 1, Section 2 of the Constitution. They said slaves would count as 3/5 of a person for census reasons. So clearly slaves weren't seen like everybody else. And they were given no rights of voting or citizenship. Article 1, Section 9 of the original Constitution prohibited the United States Congress from restricting the slave trade prior to 1808. So slave trade was perfectly legal at the inception of our nation and was constitutionally protected. And then, concurrent with this, Article 4, Section 2, said that if a slave escaped, they must be returned on demand of the slave owner. So clearly, our original Constitution did not protect the rights of African Americans. And then we have the interesting case during this era of Dred Scott, which I believe is in your book. Dred Scott versus Sanford. And this was a case that was decided in 1857, over 60 years after the inception of our new Constitution. So what was this case about? Well, the question in this case is, what is the effect of a state and federal law that grants freedom and citizenship to slaves? And what we have to understand is during this time, some states recognized slavery, some states outlawed slavery. And it was generally on a regional basis, the North versus the South, with the South being pro-slavery and the North being anti-slavery. So what is the effect of a state law granting freedom and citizenship to slaves? And what happened here is, Dred Scott was a Missouri slave, and he had been taken as a slave by his owner to the state of Illinois. And Illinois was a free state. It had laws that would not recognize the status of slavery. So once Dred Scott was brought to Illinois, he sued his owner in federal court to establish his freedom. So there was tremendous controversy over this case. As this case was being tried, and then later appealed and heard by the United States Supreme Court, there were demonstrations You had the abolitionists on the one side saying slavery was atrocious and Dred Scott should be freed. And then you had the slave owners on the other side fighting for the defense of the institution of slavery. So this case goes all the way to the United States Supreme Court. And as it's going on, one group commenting on the issues of this case said the following in regard to the question of whether and they called it a Negro whose ancestors were imported into this country and sold as slaves could become a citizen. And here's what they said, this group. They said, we think they are not, and that they are not included, and were not intended to be included under the word citizens in the Constitution, and can therefore claim none of the rights and privileges which the Constitution provides for and secures to citizens of the United States. On the other hand, they were at that time considered as a subordinate, an inferior class of beings who had been subjugated by the dominant race, and whether emancipated or not, yet remained subject to their authority. Okay, so there was a group that was saying things like that. And the question is, what group? So generally when I ask my students, what group would write something like that, I get things like white supremacists, the Ku Klux Klan. And then what I tell everybody is, what I have just read you is the majority opinion written by Chief Justice Taney of the United States Supreme Court. So this was the official legal interpretation of racial discrimination in the United States in 1857. And I'll read it again. So Taney is writing in regard to the question of, he said, was a Negro whose ancestors were imported to this country and sold as slaves eligible to become a citizen? And he said, again, quote, we think they are not, and they are not included, and were not intended to be included under the word citizens in the Constitution, and can therefore claim none of the rights and privileges which that instrument provides for and secures to citizens of the United States. On the contrary, they were at that time considered as a subordinate and inferior class of beings who had been subjected by the dominant race, and whether emancipated or not, yet remain subject to their authority. So, the United States Supreme Court in 1857 is arguing that African Americans are subordinate, inferior class of beings, and that they could be ruled by the dominant race, which was white people, and that was perfectly legal. Well, clearly this decision didn't sit well with the abolitionists. They were appalled that the Supreme Court would do this. And remember, we're talking about Illinois. So what happens is one of the great leaders in Illinois at the time, Abraham Lincoln, denounces this holding, and as a result of it, says it helped motivate him to run for President of the United States on an abolitionist platform. And he is elected. And because of his election, the southern states secede from the Union. I mean, think about that. Southern states en masse saying, forget it, we're leaving. We are not going to abide by anybody, any president, who tells us that slavery is inappropriate. And what that leads to, obviously, is the Civil War. which results in 620,000 people dying. Well, the North obviously wins the Civil War, and the national legislature enacts what are referred to as the Civil War amendments in regard to slavery, which are the 13th, 14th, and 15th Amendments to the Constitution. So the 13th Amendment prohibited slavery. The 14th Amendment provided for equal protection of the law. This amendment commanded that no person shall be denied the equal protection of the law by any state or locality. And the 15th Amendment, which provided African Americans, and I should qualify this, African American males, with the right to vote. And it prohibited the states from denying the right to vote on account of race to any male. Okay. So that becomes the end of this first era, which then brings us to the second era, which I'm referring to as qualified legal discrimination. And that era extends from the 1860s to the 1940s. Now, what do I mean by qualified legal discrimination? What does that mean? I mean, we just said that the North and the South fought a war over slavery. North won the war, implements the 13th, 14th, 15th Amendment, which outlaws slavery, provides for equal protection of the law, and provides African American males with the right to vote. So what's the problem? Well, the problem becomes, what does the 13th, 14th, and 15th Amendment really mean? What does it really mean? And this leads to a very important court case in 1896 called Plessy versus Ferguson. Plessy versus Ferguson. Now, we have to remember that the South was not very happy with the 13th, 14th, and 15th Amendments. So they really didn't want to abide by them. So they passed a whole series of laws to try and qualify the 13th, 14th, and